So I'm joined today by Francisco Villegas of Villegas Cefo, and we're going to talk about litigation funding. Francisco has a successful practice and bring those successfully to funders. So first question, Francisco, what are the things you look for when selecting which cases to take on and then look for funding on those?
Well, thank you for having me, Emily. When I look at cases that are brought by clients, or if I'm out looking for cases to develop new business, I think of, is the case going to win? And to assess that, I look at a few things. I look at the merits. How strong are the merits? Clients always think that their cases have strong merits, but you have to look at them. Also, what are the defenses? What is the other side going to raise as roadblocks to get to the inevitable third part, which is the damages? There's been a lot of cases that we've looked at where the merits were great. We did not think that there was a viable defense. But then when you dig down into, well, what can you actually extract from the litigation? What's the business rationale for this? Sometimes the damages fall flat, and you have to have that, especially in funded cases where you have litigation between competitors and it's primarily for an injunction or for other competitive reasons. That's really not that important. But with funded cases, right, you have an investor and you have the client, and both of them have to be aligned. And if you don't have those damages, the case isn't going to work. And the fourth item and the last item that we look at is the story. Is there a compelling story that we feel we could tell at trial and throughout the litigation about what makes this litigant and the claims special? Sometimes there is no story. Sometimes the story, in fact, is not so good. There could be warts on the case. There could be problems with prior corporate structure. There could be simply no story at all because maybe the claim was somehow acquired by the entity. So the story component is nearly just as important as the other items, because if you don't have the story, you may not win the judge over during the litigation, and you probably are not going to win the jury at trial.
Thanks, Francisco. I think that aligns well with our own internal due diligence process. So obviously merits and winning are important, but it is the economics or the commerciality of the case, which is often a problem in some of the opportunities that are presented to us. And until you sort of have a view to that, if there's not going to be enough in there for the funder to get their money back in a return and the client to take home the lion's share, it's not really a kind of a viable case for funding. So I think moving on, all funders are different, but obviously those same principles apply. But the general feedback in the market is that getting funding is time consuming and difficult. How do you put your cases together to get a quick decision from funders?
Yeah, so there is no way around doing hard work to get the case funded. A lot of lawyers are generally interested in litigation funding until they find out that to get a case funded requires a lot of work and commitment to the client and also to the funding process. And what that means is that a sponsoring lawyer needs to know everything about the merits, everything about the defenses, everything about the damages, and everything about the story. You need to have done the legal research. You need to have done the factual due diligence. You need to have thought strategically about what the defense is going to do. And you need to take, and of course, the damages and the storyline, and you need to take all of that information and synthesize it in a way that a funder can review it easily and that it provides a compelling story. Because even if all those facts and case law line up and you have a phenomenal case, if you don't tell that story to the funder, you're going to get a no. Because think of it from the funder's perspective, right? Somebody starts emailing, one email here, 10 emails there, send some attachments, send some articles, some Excel sheets. The funder's looking at 50 cases or 100 cases or some phenomenal amount of opportunities, and you want your opportunity to be easy to digest, and that immediately signals to the funder, this is a great case. Please give me your limited time and look at it. And the synthesis of the information is very, very important, because without that, even a great case will not get funded. And this is the only, also importantly to your question, this is the only thing that the lawyer can control, because the rest of the funding process, to a certain extent, is led by the funder. Right? The funder has to look at the case. It sometimes has to go to outside counsel. Sometimes there's committees, depending on how the funder is structured. All the lawyer can do is make sure that the information that's presented is presented well and addresses or proactively addresses questions that the funder will likely have. And that is what the lawyer should be focusing on. And then hopefully that gets you a result in as quick of a time as possible.
That sounds ideal. If every case that I looked at was presented in that way, that would be fantastic, easy to digest. And I think also setting out strengths plus weaknesses, because I've gone through due diligence on quite a lot of cases, and where, you sort of dig down and then something which would have been apparent from the beginning sort of comes out as a weakness. And then there's maybe a bit of a trust issue with the law firm. Has it been hidden?
Yet credibility, if there's something that comes out that even if it's just a marginal defense and it's the funder that points out the defense, you're going to start losing credibility. And a lot of this, I look at the funding process as first there has to be the merits, right? The merits have to be there. But there's also, as in any business transaction, there's a little bit of trust, right? The funder has to feel that the information that's being provided is correct. And also it needs to be balanced, right? The funder is your investor to a certain extent, and the investor needs to feel that the information is solid. And the funder will not be able to dig down into the case as much as the law firm will. And if issues start coming up that were not presented, and it's the funder that's pointing them out, I think that the likelihood of funding is probably going to go significantly down.
Absolutely. I think trust is key. I mean, this is a long-term project, so we're going to be involved in funding the case for multiple years, and having trust in the law firm and the client is really important for us. I think the credibility point is also a good point. We need to be able to trust that the law firm actually, understands all of the aspects of the case. And you talked about looking at the merits, but also looking at the possible defenses. And if we're flagging something, then that suggests there's been a gap in the kind of the law firm's consideration of the case.
Sometimes lawyers that are new to funding don't understand that in many instances, or I say most instances, I think, funders are hands-off, meaning once the case is funded, generally funders are not dictating how the case is run. And for that reason, it's critical that the law firm provides all the information up front, because if you put yourself in the funder's shoes, even if this information comes out at a later date, it's going to look very bad, and it's going to greatly erode the trust in what you pointed out, which is this long-term relationship of many, many years. Critical that all the information, good and bad, is disclosed up front.
That's right. And I think by doing that, it means that the funder can properly risk assess the case and go into the transaction with their eyes open. So I guess this leads me on to my next question quite nicely. Once the case is funded, how much interaction do you normally have with the funder, and how can you make that an efficient process during the course of the litigation?
That depends. Some funders have been very hands-off. They fund the case in the beginning. They ask for periodic status reports. Sometimes I don't receive many, if any, responses from the status reports, and my interaction has been limited to simply asking for drawdowns, and that's it. Other funders take a more active approach. And by active, I mean they want to engage in the status reports. They want to talk about the merits of the case. From my perspective, I prefer funders that are active. And the reason I like that is I feel that funders first are detached from the litigation. And if I'm not convincing the funder, or if the funder raises issues that either I haven't focused on or perhaps I've not addressed to their satisfaction, it gives me an opportunity to think about my own case. And I find the feedback from funders, both funders that have strong IP departments, which is what my practice is, and those that do not, I find that all the questions that I receive simply help strengthen the way that I look at my case and prepare me to defend the merits of my case. And so I greatly appreciate their feedback. After all, they probably have a stable of cases that they're looking at, and anything that they can contribute to the litigation, I want to know about it.
I think sometimes from a funding point of view, it's quite nice to have that sort of high level view over what's going on in the case, and to ask a few questions. And that also helps with the sort of continuing the trust, because when the answers come back and they're sort of well thought out, and we can really understand how the case is moving forward, that also helps with the relationship. So last question, what are your 3 top tips for working with funders?
Prepare. The preparation is critical. And this is the difficult part for lawyers and law firms, because to get a case ready for the due diligence process takes a tremendous investment. This isn't 40 hours or 80 hours. The due diligence goes into the hundreds of hours. And one of the benefits of that, however, is if you do get the case funded, all that due diligence has simply made your case ready to not only file, but to go to trial, right? You have already looked at the requirements for filing of the case. You've already looked at the defenses. You've already looked at the damages. You've already looked at a lot of what and developed the case that will eventually, hopefully, prevail. And so item 1, be prepared. But item 2 is not to be discouraged. The likelihood of getting a case funded on the first call is probably low. But if you prepared your case, you should take the no's from the funders as an opportunity to perhaps address shortcomings that you didn't see. So if you prepared well and the funder finds something that makes the funder nervous, that you should take as an indication that you need to perhaps increase the amount of research, or maybe find more facts, or perhaps present that argument in a different way. And you should take those no's, improve your presentation, improve your data room where you keep your repository of documents, and in the next go around, right, have a stronger case that then will hopefully be funded. And this is a very difficult thing to accept, right? Because when you get a no, you take it very personally. A lot of time's been invested. But if anything, you should use the no's in the process as an opportunity to further refine what it is that you're trying to ultimately achieve, which is to find financing for your client. And then number 3, you should do, if you can, some due diligence on the funders. And what I mean by that is certain funders have certain tastes. Some funders like certain kinds of commercial matters. Some funders hate intellectual property matters. Some funders like software matters. If you can, it's important to assess, well, what is this funder looking for? And what is this funder's appetite to deploy capital? Because there's a lot of work that goes into not only the due diligence to get your case ready, but also in the presentation of those materials to the funder. And so if you can target a few funders that you believe you have the highest chance of success, you should do that instead of sending 40 emails out and hoping for the best, because you're going to get a lot of no's. You might waste a lot of time working with the funder when in reality that funder at that particular point can't deploy capital. Maybe you're pitching the wrong kind of case to a funder that generally is known to support or reject certain cases. So it's important to know a little bit about your audience before you engage in this process, only given the amount of time that's spent on both sides. You'd be saving yourself time, and you're also saving that funder some time. And as you get more and more involved in litigation, you want funders to know that you're going to present things that they want to see. And if you're presenting things that are just not in their wheelhouse in terms of subject matter, you'll begin to receive a reputation that you're willing to pitch anything out there, and perhaps you're not the one that they should take their phone call. So it's important to have all these 3 items together in order to hopefully get the results that you want for your client.
Thanks, Francisco. They were great tips. I wholeheartedly agree. Don't be discouraged, because that goes into the knowing the funder and what they like and don't like. And it doesn't mean the case is a bad case. It may just be the funder's risk appetite at that time. And I think the other thing to ask funders about is their capital adequacy. Do they have sufficient funds to actually fund the case? How are they structured? Where's the money? How is that going to be deployed? Will that be immediate, or is there going to be some sort of delay in that coming forward? Because, that all goes to timing of filing the suit and approving the funding. So I think hopefully those add a little bit from the funder side. But I think it's been really good speaking to you today, Francisco. Hopefully everybody has taken a lot out of that and can prepare cases that make my life easier. And we'll see much more in respect of strong cases for funding.
Great. Thank you, Emily. Thank you for inviting me.